Federal High Court in Abuja on Friday reserved judgment in a suit seeking to stop the release of federal allocations to the Rivers State government. Justice Joyce Abdulmalik reserved judgment after all parties had argued for and against the originating summons filed by Rivers State House of Assembly led by Right Honorable Martins Amehule. The plaintiffs predicated their case on the grounds that the Rivers State Executive was yet to comply with the order of a federal high court directing it to represent the 2024 appropriation bill to the Amehule-led faction of the Rivers State House of Assembly. It will be recalled that Justice James Omotosho of a federal high court had in a judgment delivered earlier in the year faulted Governor Siminaye Fubara for presenting the state appropriation before the four-member assembly led by Right Honorable Edison Ehe. Justice Omotosho ordered Governor Fubara to represent the appropriation bill to the Rivers State House of Assembly led by Martins Amehule. In view of Fubara's refusal, Amehule approached the High Court to stop further release of federal allocations to the state until the judgment of the court was complied with. But the Central Bank of Nigeria, listed as first defendant, urged the court to dismiss the suit for being frivolous and that the said judgment of Justice Omotosho is already a subject of appeal at the Supreme Court. The Rivers State Accountant General had filed a motion on notice where he accused Justice Abdulmalik of bias against his office and other defendants in the suit. Represented by Tuturu Edem, SAN, the Accountant General faulted the manner the judge had been conducting the proceedings, describing it as strange and unbelievable. The position of the Accountant General was adopted by the CBN and all other defendants. However, in her ruling, Justice Abdulmalik said that she would not recuse herself, adding that she was not biased as alleged. The judge also refused to decline jurisdiction and a request to allow the Federal High Court in Port Harcourt take over the proceedings. Justice Joyce Abdulmalik held that the territorial jurisdiction of the Federal High Court was one across the country. The judge also held that the Chief Judge of the Federal High Court has the discretion to assign any case to a judge of his choice. He therefore ordered that hearing in the substantive matter and the preliminary objections should continue. After all parties had made their submissions for and against the main suit, Justice Abdulmalik reserved her judgment for a date to be communicated to the parties. Ugochukwu, what do you make of these developments?
In interesting times in Rivers State, interesting times in Nigeria, and the Ministry of Justice, the law courts, and the Nigerian judges are on a test ride. They are also in the eye of the storm. I don't envy any judge, especially those who have been saddled with the cases emanating from Rivers State, as vis-a-vis the local government, between the local governments, between the State House of Assembly and the Rivers State executive arm. You know, it's been accusation and counter-accusation, and I don't know whom they want to, handle those cases. You give it to Omotosho, delivers judgment, he's biased. Justice Lefu delivers judgment, is biased. Now the attention have shifted to Abdulmalik. I mean, what do we want as a people? Because I, who is domiciled in Rivers State, let me ask, what exactly do we want? You know, the next leg of it, people are, yesterday, Falana was accusing the same Abdulmalik to rescue herself from the state judgment, a certain judgment, and citing that the FCT minister is building houses to be allotted to judges, that it will elicit bias and sentiment. And I ask this question. Most of the judges that are functionable in Rivers State now, who appointed them, whose regime did they come on sit? You know, we know what Nyesowike did in terms of alleviating the plights and giving a sense to the judicial officers in Rivers State. And nobody has accused Justice Nwite and Justice Wale and some of them who has been hearing the cases on behalf of the local government and also turning out frivolous and the counter orders by Court of Coordinate Jurisdiction in Rivers State. Nobody has accused them. The camp of Nyesom Wike have not mentioned them as people who are now, being a clog in the wheel of those cases. But it beats my imagination when people begin to make unfounded accusations and allegations. Okay, if you draw this issue to the case handled by Justice Omotosho. Justice Omotosho, after looking at the case, the state executive appealed to the appeal court. And the appeal court also sat and looked at it and granted merit to what Omotosho have said. Now it is before the Supreme Court. I now ask, if Omotosho have been biased as alleged, has Wike also influenced those at the apex court? So these are some of the things you see in Rivers State. You begin to ask yourself, are people really following the letters of the Constitution and the fractions being put out for the public to see? Or are people beclouded by their sentiment and bias and mixing morality or whatever religious sentiment you have against the letters and the tenets of the law? These are the questions our people should begin to ask themselves. All those cases they are turning out from the camp of Amehule, and the governor's camp is appealing it. If it is unfounded, why go on appeal? Because once you appeal a judgment, that means you are in agreement and alliance with the letters that the law has pronounced, given the constitutional backing that is, surrounding whatever case that is emanating thereto. That is the way I see it. So begin to, counter accuse and mentioning names will not save this matter. Will not make and I'm so delighted that Justice Joyce Abdul-Malik has stated it clearly, because I cite this example, Laurentia. In the United States Constitution has it that wherever the United States Embassy is, if a woman that is pregnant or somebody is running away from state authorities, and you find yourself by any means whatsoever inside the perimeters of the fencing of the United States Embassy anywhere in the world, you are protected at that moment, and the child giving birth within that periphery becomes an American citizen, be it in Afghanistan, be it in Nigeria. So the Constitution have stated that, and I bent to agree with the learned Justice Joyce that Federal High Court anywhere is Federal High Court. It doesn't matter whether it's in Rivers State, whether it's in Zamfara or Jigawa State, it is a Federal High Court. And those justices serving under that in the name of the Federal High Court can be, assigned cases and reassigned cases, or even sent on transfer within the so-called justices of the Federal High Court, no matter where it's existing. So for somebody to come out and be saying that we know the instances where a judge can be asked to rescue him or herself from a case, but not is on these frivolous accusations that holds no water for me. Because if you say that those courts and judgments are not anything to go by, don't appeal and let us see how the person is now bigger than the constitution of the country. And for me, whatever Justice Omotosho have said in the January 2022 judgment still subsists, because it has been affirmed by the appeal court. Therefore, it has a lifeline. It has a life, and its lifeline is very potent and has the teeth to bite. And until that particular judgment is set aside, Because remember, Justice Omotosho gave a judgment, substituting judgment. He didn't give an ex parte order. He didn't give an order of interlocutory injunction. But it was a judgment turned out from his temple, and the appeal court has affirmed, in without mincing any words, upholding all what Justice Omotosho has laid out. And for the Martin Samehule to go to the court before Justice Joyce to ask that the funds of the River State be withheld within the time being until we have had this we have gone through the whole hog of this litigation. It is really apt, it is really timely, and though for me it is belated, because even the so-called presentation of the budget is we already seeing the tail end of 2024, but it cannot be overtaken by events. What I'm saying in effect is that the Martin Samuel and his brothers of the 27 lawmakers have the right to appeal, because Justice Omotosho, they are benching their consign and this particular case on the judgment given by Omotosho. Let us even forget about the affirmation by the appeal court. Justice Omotosho gave a clear judgment. So that is why, for me, in my own view, I'm saying that Amehule and his brothers has even taken a lot of time before approaching the court to stop all these shenanigans and all these because immediately the governor's camp appealed that particular Justice Omotosho's camp. That is when Amehule should have gone to institute a new case, asking that and drawing in all the people concerned, the Attorney General, the Attorney General of the Federation, the Accountant General of the Federation, the CBN, and the Minister of Finance. All of them should have been drawn in the case, knowing that they oversee the disbursement, and and those who are also empowered by law to take actions. That is why I mentioned the Attorney General and the Chief Justice of the Federation should have been drawn to the case. The Federal Minister of Finance, whose budget also oversees those particular escrows and disbursement, should be drawn to the suit. And then let us see where the loopholes are. Okay, let me draw this an analogy. When the federal government of Nigeria, during the Olusegun Obasanjo administration, stopped the disbursement of the local government allocation to Lagos State, and Bola Tinubu's administration went to court, the federal government withheld that particular allocation until the Supreme Court made the pronouncement. They did not wait until the Supreme Court made the pronouncement before they withheld. Rather, after the litigation, they now obeyed the Supreme Court judgment. So, in my view, when Justice Omotosho have made that particular judgment and pronouncement, the federal government, those saddled with the responsibility of disbursement of that fund, would have stopped it until the litigations all those appeals are had. All those appeals, and then waiting up to the Supreme Court, let us know that as soon as the Supreme Court pronounced that it is wrong.
No, the judgment did not. The judgment of Justice Omotosho did not order these bodies to stop payment of allocation. The court cannot grant you what you did not pray for. And that is why, in this instance, perhaps that informs why the Rivers State House of Assembly has gone to court to actually seek this prayer to stop payment of FAC allocation pending when the governor obeys the court judgment. Now,
pending the Supreme Court judgment.
This is a different
judgment.
Issue. Listen, let's get it clear. The Supreme Court's appeal, the governor went to Supreme Court to appeal the judgment of the appeal court, which affirmed the judgment of Justice Omotosho and prevailed on him to present the 2024 budget to Martin Samehule.
Clearly.
Now, that's a different case altogether, because in that case, these bodies were not, part of the prayers of that case was not
among those bodies
stopping the CBN from paying FAC allocation. Nah, that wasn't part of the prayer. Here is the governor is challenging the judgment of Justice Omotosho. And he's challenging it because of two things. First, he has to present, the judgment says he should present the 2024 budget to Martin Sameule, led House of Assembly.
Clearly.
And secondly, the fact that that judgment authenticated Martins Ameule
as a substantive House of Assembly
Speaker and the 27 others. These are the two major issues the governor has with that judgment.
Yes.
So let's get that clear. This is an entirely different suit. And this suit is asking the court to order these bodies to stop payment of FAC allocation to River State until and unless the governor does what has been clearly stipulated
in the judgment of Omotosho.
Judgment of Omotosho, and also upheld by the appeal court. Right. Now, part of the arguments the defendants have is that they should wait for the Supreme Court judgment. Now, this still brings me back to the first statement I made. Telling the court to wait for the Supreme Court judgment, the matter is already in court. Is it not a different matter?
Yes, it is. I clearly get
so
what you
why would this suit wait? Why would it be suspended pending when Supreme Court gives judgment? This is an entirely different ball game altogether.
Yes. Okay, now I clearly get it. And that's why I also made a statement that Martin Sameule and his House of Assembly members should have gone to court immediately they saw the handwritings boldly written on the wall that the government of River State were not yielding to the judgment of Justice Omotosho. So they have left it, for me, they have left it too late to go to the court, though it will not be overtaken by event. Because any particular expenditure that is not, guaranteed
when you
within
say it will not be overtaken by event.
Yes.
Are we not almost there?
No.